equal time sharing means equal. In the state of Florida, the presumption is that you need to do nothing to prove that you are entitled to equal time sharing. To the contrary, my friends, the other side has to prove by a preponderance of the evidence that you are not a suitable parent fit enough to have equal time sharing, which means that the burden is on the other side. When you request equal time sharing, per Florida statutory law, you are supposed to be guaranteed equal time sharing, whether the other side likes it or not. So, why is it that people are often litigating this issue constantly? Why are lawyers telling their clients that they are entitled to majority time sharing just because the other side missed one appointment, or if a parent is withholding their child, that somehow that means that the other side is a terrible parent, an unfit parent, an unsuitable parent, and should not have any time with their minor child? In my mind, this is a very real problem. A very real problem when counselors tell their clients that the other side, just because their client doesn't like them, is not entitled to equal time sharing. Because then you're setting them up for failure. You're setting them up for hearings that should never happen. You're setting them up to go to court to antagonize and alienate their co-parent and tell the entire world what a wretched, terrible person they are simply for existing. And then at the end of the day, that person who withheld all time sharing kept the other parent completely in the dark, gave them absolutely no time with their child, and intentionally created a rift between that child and that parent. Guess what? That parent now surrenders 50% of the time of the other side. And the damage that they have done. Think about that. Alienating your co-parent? Alienating the mom or dad of your child for months or years. Treating that child like a piece of property? For what? When Florida changed the law, equal time sharing didn't become a suggestion. It became a presumption. A presumption of equal time sharing is a very serious legal precedent. It is foundational. And it's not optional. If somebody goes to court and says, Your Honor, I want equal time sharing, the judge doesn't say, oh, well, I don't know about all that. I mean, I don't think so. I don't really like the way that you are, or you behave, or you just don't strike me as equal parent material. Well, then, the other side has to prove by a preponderance of the evidence, which may not be the highest standard, quite frankly, that you, as the person essentially on trial, and by the way, you're not really on trial if you're asking for equal time sharing. It's quite the contrary. Technically, the other party is on trial because the burden of proof is on them. But you're essentially on trial of what have you done to deserve this punishment where you're not allowed to see your child half the time? What have you done? Do you work 17-hour days, 7 days a week, and you're never available? Do you put your child in harm's way? Do you endanger their safety? Do you neglect them? Do you have a severe substance abuse problem or anger management problem or gambling problem that's ever present in front of your child, not just behind hidden doors where your child has no idea? Do you show up late every day and drop your child off at school and create a truancy situation? Do you take your child to dangerous places intentionally and expose them to harmful things and harmful situations? I mean, if you're not doing these things and your only sin is that you do not get along with your fellow co-parent who withholds time sharing from you and refuses to allow you anything and creates that barrier between your child and yourself for selfish reasons, quite frankly, as it's in a child's best interest per public policy, per the state of Florida, maybe per the view of most parents, that there are two parents involved in that minor child's life, two protectors, two financial sources, two individuals who care about that child enough to provide for that child. And now, what do? You file a motion for temporary relief and tell the judge that you want equal time sharing. You take your case to trial and you tell the court that you want equal time sharing. And if the other side is foolish enough to give you no time sharing, to be a wretched co-parent who withholds your child and provides you no information about them, blocks you access to their school, to their daycare, refuses to allow you to go to medical appointments and simply demands that you pay for all of this while they're creating this situation where it's impossible for you to see your child without law enforcement and court intervention, well then, if they're the ones that call the case for a hearing to try to get less time sharing for you, well, then you have a presumption of equal time sharing. And if you are prepared and you've acted rationally and reasonably, there's a really good opportunity for you to achieve equal time sharing, and I would argue maybe majority time sharing, because the other party has proven themselves to not care about the best interest of their child.